I don't mind telling everyone this. I'm not really that concerned about subsequent rulings. I'm concerned about my rulings.
We're not talking about they're
Okay, next up, page 10 of the calendar, Hunter Brown versus Affinity Lifestyles. .com Inc. etc. Oh yeah, we got a lot to talk about. All right, good morning. Let's go ahead and set forth our appearances for the record.
Morning, Your Honor. Eric Pepperman and Teddy Parker for plaintiffs.
Good morning, Eric Freeman and Joel Odou for Real Water and Affinity Lifestyle.com.
Morning, Your Honor. Jim Cavanaugh for ETT1 DBA Terrible Herbs.
Good morning, Your Honor. Colt Dodrill, counsel for Nevada Beverage, bar 9000.
Good morning, Your Honor. Jim Neal for UNFW and Whole Foods.
Lou Brandon, present also for UNFW and Whole Foods.
Your Honor, Joel Odou on behalf of Real Water. My colleague Matthew Kaufman is observing. I think his ProHoc is on for today.
All right. Does that cover all appearances? For check-ins. Let's go ahead and deal with the ProHoc issue.
Thank you, Your Honor. Joel Odou on behalf of Real Water. I don't believe there's been any opposition. Mr. Kaufman assisted in the prior 3 trials. We were requesting permission to have him assist in this trial.
Right, and there's no objections, right, Mr. Peterman?
No opposition, Your Honor.
All right, we'll go ahead and grant that.
Thank you, Your Honor. We'll submit an order.
Okay, and before we get to the pending motion, I'm looking at where we're at, and it's my understanding the motion in limine, the dispositive motion deadline, is that August 28th? Is that right?
Yes, Your Honor. I believe we just submitted a stipulation to bump it a couple days to the 28th.
All right.
Yes, Your Honor. Okay.
Now here's my next question. We do our calculations, and I guess 14 days after that would be, I guess, 9/11/2024, and with the replies due 5 days after that, where does that put us as far as in limine motions? Because the way I see it, we'd have probably less than 2 weeks before trial, right? And here's my next question. Are we going to re-argue all those motions that I heard before?
Judge, you are on top of things.
You are.
We were just talking about that outside the courtroom.
Well, and here's my point. You know how, Mr. Parker, I think down the road,
You do.
right? I think down the road. And so this is a case management issue that I have to deal with, and I recognize it. And I have a lot of questions about where we're at, but what do we do with this issue? Because I'm sitting here and, for example, if some of the prior in limine issues are factually exactly the same, why would I rule differently?
Your Honor, I agree. We were talking about this outside just before we walked into the courtroom. We were also planning, I think Mr. Freeman came up with this idea, potentially informing the court of the additional rulings in the subsequent cases. And perhaps as we speak to among ourselves.
But I'll tell you this, I don't mind telling everyone this. I'm not really that concerned about subsequent rulings. I'm concerned about my rulings. You see where I'm going? Because, for example, if I granted an in limine motion and it's exactly the same issue in this case, why would I mean, I understand we have to sometimes make a record, and potentially we can incorporate, if everyone agrees, the argument from the prior hearing on that specific issue. But here's my point, and this is what's a little bit different now. Number one is this will be what trial number 4 or 5?
4.
Okay, this will be trial number 4. That's what I thought. And as far as and I realize I do understand this, and this is kind of my observation. I haven't had a chance to dig deep in it, but it appears to me that this case might involve slightly different medical causation issues. There's issues regarding pre-existing conditions and those types of things. So I understand that. So I'm not really dealing with those issues, but some of the really factually, it's all the same. And as a result, Judge, would I rule the same way as a matter of law? I would hope so, because we spent a lot of time on some of those issues, right? Now, I realize there might be issues regarding medical causation, pre-existing condition, and things like that, and we might have to ferret that out. And ultimately, maybe that goes to the jury. I get that, but where do we go from here from an efficiency perspective? Because I want to make sure we can start trial on time.
Well, when we have the required meet and confer on the motions in limine, Your Honor, we can determine at that point the ones that we intend to refile. And to the extent that they've been filed in the Gallagher case, we can indicate the court's decision
Yeah.
on those and whether or not we're willing to simply accept those decisions in this case without oral argument. We can put those in front of the court, and the ones that are new, and those are the ones I was alluding to earlier. There may have been some new ones that we brought before the Judge Kishner and Judge Hardy. And we could submit them in this case, and we could also.
Yeah, because I want to hear those. If it's
Yeah.
something new that I haven't had a chance to specifically review and rule on, of course, I want to hear it. I'm not going to rely upon what another judge did. I'll just be candid with you.
Sounds good.
Your Honor, could I ask in terms of the court's availability for hearings on these motions, if you have an idea of what your trial schedule is going to look like around that time?
Well, from what I gather, and I'm just looking at this, is this correct? We couldn't start hearing these until the 23rd. Is it 22nd is a Sunday?
That's what
Right. And tomorrow's our pre-trial calendar call. You got a firm trial setting, so you're number one. This is rough estimate, but I think we couldn't start hearing these until, from what I gather, the 23rd. Then I'm going out of town the 26th and 27th. Then we go the 30th, the week of the 30th, up until the 4th, and then we start trial the next week. We don't know we have one.
we won't know if we have a trial that last week until tomorrow.
Oh, yeah. Is there, because there's another matter on calendar to set up.
So maybe we can, so Your Honor, maybe we could have the motions heard the 23rd through the 25th. I don't know if we need all 3 days, but that would be sufficient, I think, given how much time we spent in the most recent case. We won't have many new motions, I don't believe.
Yeah, Mr. Odou, sir.
Thank you, Your Honor. Joel Odou for Rural Water. I happen to be on the court's calendar call for tomorrow. I've spoken to the council.
That's right, you have two matters, right?
Yeah, and they have a calendar conflict, and so they're gonna ask for that trial to go the week of the 16th to the 20th, and I have no objection to that. I just want to give the court a preview. Obviously, they're not here. I don't
Yes.
open any cans of worms.
I mean, if everyone's agreeing, Mr. Odou, I don't have any problem with that.
Appreciate that, Your Honor. What Mr. Pepperman and Mr. Parker propose is completely reasonable. What we would anticipate may happen is we may have typical motions eliminated that the court needs to rule on, just like always. We may have a group of motions eliminated where we would incorporate arguments previously made, if that's acceptable to the court, and submit those either on the record or based on the court's prior ruling. That's the one I'm a little bit fuzzy on, and then there may be motions eliminated that people still want to brief and have the court rule, even if the court's ruled already. I'm trying to anticipate what everybody, not necessarily what Real Water may do.
I understand, I respect that, sir.
So that would be my thought. We work a lot of this out in the meet and confer, and at least give the court a list of, motions eliminated that the court's either ruled on completely, and we agree to incorporate that, just so the record's clear for any appellate issues, and then there may be motions eliminated that people still want to brief.
That sounds fine, Your Honor. And we, like Mr. Odou said, we can handle a lot of this at the meet and confer, so.
Mr. Cavanaugh, what do you want?
I agree, Your Honor, the meet and confer is a necessary threshold matter to begin intelligently presenting time periods and such to you. Just point out, my client wasn't in the first Gallagher case, as no retailers were. Anyway, We'll know a lot more after our meeting for next Monday, Your Honor.
Okay. So tell me,
out, they just said.
Not in Gallagher. They were never in Gallagher.
No.
Terrible Herbs.
Terrible Herbs wasn't. I'm saying retailers were. You said no retailers were originally a part of that case.
I'm
They
not
didn't go
aware
to
who the
trial.
retailers were in
Right.
Gallagher. Who was that?
I said they were in the case. They settled before trial.
I'm not aware who they were.
UNFW was one.
UNFW is a distributor.
Okay, but.
Retailer would be.
Whole Foods was actually a seller.
Whole Foods was not a defendant in Gallagher, to my knowledge.
Okay.
But
I don't think it
wrong,
really matters. I mean, and here's my point.
Let me just help him out. Mr. Haley worked at Whole Foods, bought his retail water from Whole Foods in Gallagher.
well aware.
Okay.
But Whole Foods was not a defendant. No retailer was a defendant in the Gallagher matter.
Right. Well, it doesn't, gentlemen, I'm not really.
I mean, Teddy.
You can talk about that at the meeting in front.
Yeah.
Sounds like a good idea, y'all.
You know, but what I'm trying to do is really focus on efficiency right now. And I think we have to be concerned because we don't have a lot of time. But yet we have a trial coming rapidly approaching for all practical purposes. The trial's tomorrow.
That's
Right.
correct, John.
You know, and I realize this will be the fourth trial, but a lot of the facts will be the same, but there'll be slight nuances and it's stress trying a case. I get that. And so so today is the August 21st. We should probably have a status check as to how this was resolved at the meet and confer. Because I do need to have planning. I do. We have to, and the reason why I want to have a status check, I want to force you to make some decisions.
Your Honor,
Do us too well.
I do think, the availability for hearings will factor in the meet and confer because we can certainly try our best to come to an agreement. Our view is if you previously ruled on the exact issue, there's no point of re-arguing it. But if
And especially because this is important to point out, Mr. Pepperman, it's not like we didn't really and truly spend a lot of time vetting those issues.
5 weeks, John.
5 weeks, and
I think everyone's gonna
Certainly
largely
you did, Your Honor, but a notice.
No, and I'm
opportunity
not saying-
to be heard.
no, I'm
No retailer in that first case.
I get
Including
that.
my client.
Yeah, I get that. But I understand.
But I agree in principle, everything Mr. Peppermint just said.
and it could also be
But at
that
the
we
end of the
submit some
day-
briefs.
Yeah, but here's my point. At the end of the day, does it really matter when it comes to the restatement of torts for 2A? And the consumer expectation test as set forth by our Nevada Supreme Court, right? Because the retailer would be in the distribution chain, right?
Imagine that.
Well, that we are.
I agree, Your Honor.
Well, and here's my point. I just remember last.
They were in the distribution chain.
Yeah.
That's true.
Yeah, and because I think we did have some argument by members of the distribution chain last time and said, well, what did we do wrong? I said, well, you were in the distribution chain. The law is the law, right? And, and just as important, remember, and I think this is often overlooked I won't say often overlooked because lawyers that, practice these a lot as far as products liability, they're very familiar with this, but at the end of the day, when it comes to making that determination, I'm focusing on the product, not the conduct of the parties, right? Now, that can have an impact potentially from a punitive damage perspective. I get that. But we're talking about a defective product and reasonably dangerous in the restatement of torts 402A, right? The thrust is on the product. Not necessarily what, you can have all the best intentions in the world, and if that product's defective, it's defective and there's liability. That's kind of how that works. So I want to make sure we don't sidestep what the law mandates. And I know we won't. So when is the meeting convert going to be again?
Monday.
Monday.
The afternoon. I hope we've got that set.
How about a status check next Thursday? You got too quick? No, we don't have to, not for this one. I just want to give more time to, after, a few days after,
So that'd be the 29th, Your Honor?
the 29th.
Your Honor, the real water and plaintiffs have a status check with Judge Hardy at 9 o'clock. If we could make it 9:30 or later. It's not gonna be a very lengthy
We
status.
can make it at 10 o'clock. How busy is that calendar? For?
I didn't check it, so I don't know.
We can do 10 o'clock.
That'd be great, guys. Thank you.
Sounds
Yeah,
good.
and it's gonna be a status check regarding status pretrial motions. And whether there's any agreement in that regard.
Very good.
Thank you, Your Honor.
Thank you, Your Honor. Yeah, 29. We have a status check, which is already done. 9.
Yeah, because we have to, we have to, right now, we have to start thinking about, trial management issues. We do. Where are we at as far as jury questionnaire? Where are we at as far as the jury questionnaire is concerned? Mr. Pepperman.
I will, Ms. Switzler is handling that for my office.
Yeah, there's no disputes on the jury questionnaire. Everybody responded to Ms. Whistler's last email. So I think we're moving forward.
Yeah, they confirmed the timing on
Okay.
bringing the jurors in and when we get the questionnaires. I'm not sure if the jury questionnaires have been delivered yet to jury services, but they will be prior to them bringing in the first batch. I think they sent out summons. I don't have a command of the exact dates, but I know they were going to send out the summons to bring them in to fill out the questionnaires later next month.
Yeah, I'm looking here. We have, this is a correspondence from the Switzerland. To Lynn, we will have 610 copies of the jury questionnaire delivered to Department 16 on or before 9/13. And the final list of stipulated excusals to the court no later than 10/3. All right.
Those are the dates. Yes, Your Honor.
So I'm kind of anticipating at some point they'll bring him in, and I'm gonna do just like I did in the prior case. You can come down and watch if you want to, but I swear them all in. I say a few things, not much different than what I do in board hire, and I explain to them the importance of filling out the questionnaire truthfully. And if they have hardships, don't talk to the staff. They better place them or discuss them in detail in the questionnaire, because I'm gonna read it and I'm gonna make the ultimate decision as far as that's concerned. I let them know that. And just as important too, the reason why I swear them in, because this actually is part of the board hire process. It really and truly is, right? And they should be sworn in before they fill that out. And that's what I do, and I spend maybe about 5 minutes or so talking to them. But I think that's very important, because hopefully that helps with the responses being more meaningful. And that's what you want, right?
Absolutely.
We appreciate it, Your Honor. Thank you.
Okay. So have we taken care of all the housekeeping issues?
Your Honor, I have one question. Colt Dodrill, bar 9,000, counsel for Nevada Beverage. With pretrial motions due the 28th and the status check on the 29th, do you want any special designations on the motions filed? I think you did that in the Gallagher. I wasn't a party to that, but I think there was something you wanted in the caption just to flag it for your chambers.
I mean, if we did that and there was no objection and it appeared to work, I have no problem with that.
Your Honor, I believe what he's referring to is instead of filing it and saying hearing requested in the caption, we put per court's instructions, hearing set on X date, but we had dates at that time. So in terms of filing the motions, if we don't have dates, I don't know if there's really anything we can do on that.
Yeah, and you have to have dates, and what can happen, and this is what we don't want to happen. We don't want to have you file your in limine motions, and sometimes what happens, you get hearing dates after trial starts. Right?
Exactly.
I understand, sir. And so I guess maybe we should work with this as the rolling date for all hearings. September 23rd. And sir, I'm glad you brought that up. And that makes it easier. You could say September 23rd per court order
Sounds good, Joel.
at 9:30. And that would be the date. We're not gonna hear them, of course, all on that date, but that's the date that would be appropriate. And that'll alleviate confusion in the clerk's office.
Yes,
Thank you, Your Honor.
Thank you, sir, for pointing that out. Okay, is there any other?
Was there anything on calendar tomorrow here, Your Honor? I don't believe so, but yeah.
I think we have 3 summary judgment motions on calendar.
In this matter? Scared me a little bit.
I don't, let me take a look, sir. From what I gather, the only future matter we have set right now would be September 5th, 2024, status check, proof of funds transferred to, Trevor Bell after 18th birthday. Is that pursuant to some structure or something like that, or
I believe that was a minor's compromise.
minus compromise? Okay, I got you. Yeah. And that's the same day as the evidentiary hearing starting, so there's nothing set until then, sir.
Thank you, appreciate it.
Thank you, Your Honor.
All right, you're welcome. Okay. Is there any other housekeeping matters we need to address before we get to the motion? Doesn't appear to be. Yeah, I think that was very, very fruitful. We got a good perspective, man. Okay, and so let's go ahead and move on to the Hunter Brown versus Affinity Lifestyles, plaintiff's motion for a summary judgment on the doctrine of issue preclusion. All right, we'll hand it to the plaintiff.
Again, good morning, Your Honor. Teddy Parker on behalf of the plaintiffs in this matter. We've brought what I believe to be a fairly straightforward motion pursuant to the 5-star capital case, 124 Nevada, 1048, 2008, Your Honor. To put things into context chronologically, Your Honor, we had the first trial in the real water cases in this court before Your Honor in September of 2023, with a judgment being decided by the jury in October 2023. The second case was the Hunwartson case before Judge Kishner. That case started in January, I believe January 16th, with a decision being rendered by a jury in February 2024. Then the third case was in front of Judge Hardy, and that case began in May of this year, with the judgment being provided by a jury in June of this year. Each of the three cases resulted in significant compensatory awards, and all three also resulted in significant punitive damages awards. Your Honor, our motion, like I said before, is fairly straightforward. We cited to the cases dealing with products liability from the 1966 Shoshone Coca-Cola case, which is 82 Nevada 439, the 1994 Allison versus Merck case, 110 Nevada 762, then a more recent 2017 case, which is the Ford Motor Company Treo case, 133 Nevada 520, which certainly focuses on a consumer expectation test that the court was referring to previously. Your Honor, we believe that based upon these prior decisions, jury decisions, that each of the 4 factors under 5-star capital have been met. Additionally, we believe that the concessions made by Real Water in these cases have also support the use of claim preclusion, as they've all been necessarily and actually litigated. The issues are identical. The rulings have been on the merits, and Real Water has been a party defendant in each of the 3 prior cases. Real Water will argue that Judge Kishner denied a similar request in front of her. And the reason why Judge Kishner denied it originally is because we didn't have a 54B certification in this case, in the Gallagher case. In fact, Judge Hardy ruled in our favor on this very same motion as to Milwaukee in the most recent Wren case in 2024. So I don't believe that there's any true factual or legal support for Real Water's opposition. One thing that was mentioned both in our brief as well as in the opposition from Real Water is a citation to the record before Judge Hardy. I wanted to bring that document forward since one, in terms of our motion, we cited the verbatim language, but we didn't give the court the page before, the page after. And in the opposition, they didn't give a couple of pages before and a couple of pages after. So I brought copies for everyone. Can I get a vote, John?
Oh, yes, you can.
Would you like to copy?
Sure.
Jim.
Appreciate it. Thank you.
I got enough.
Oh, okay, you got it, thanks.
And Your Honor, before I get to this document, you may remember. We had this issue come up before, Your Honor, in the Gallagher case. I created a timeline as part of my opening. And the timeline provided the dates, significant dates, including when the FDA called for the recall, the testing and the determination of hydrazine, the filing of the complaint, and eventually when Real Water conceded. And we were using that to combat Real Water's claim to the jury, trying to endear themselves to the jury, I believe, that we conceded a long time ago. We didn't put these plaintiffs through a lot. Well, our timeline, in fact, informed the jury that after 70+ depositions, 26 experts, months and months worth of work, actually years worth of work, they finally conceded. And so Real Water made the argument to the court that we shouldn't be able to use those dates. And the court ultimately said, no, he should be able to use it to perhaps refute that Real Water did this of its own, voluntarily sooner than it in fact did. And I will tell you, each of the other judges agreed with this court's position when it came to this motion or this issue. So what I've given the court now is Judge Hardy's court, and that discussion involving the same issue. And I gave you the first 3 pages, Your Honor, just so you could see that first is the transcript. But the second page says the appearances. You can see that Matthew Kaufman, Joel Odou, and Eric Freeman were there on day 4 of the trial. And then the third page tells you when the openings were given by the parties. Defendant Real Water's opening began at page 106. But before I could use that slide that had those dates, Mr. Odou objected to it. And that starts on page 64, Your Honor. And Mr. Odou says, we didn't want to argue the merits of that one, so we'll address those for each one. And then the bottom says, the other one was a motion in limine that the court denied, again without prejudice. It was about the timing that Mr. Parker intends to offer in terms of, what the outbreak occurred versus the trial, when the trial began. And that should probably refresh the court's recollection to the same arguments that came before Your Honor in the Gallagher trial. If you go to line 6, it says, what is controversial, though, is the concession of liability that Real Water is defective and unreasonably dangerous. Going back to, again, the restatement second clause. It says, they have that date in April 2024. We note that the record before says gallery here should say Gallagher would place, as they said face, which should be placed sometime in September of 2023. There was a concession that Real Water is defective and unreasonably dangerous, and we believe that concession, if you will, is binding on Real Water. And they will try to go back, and in any case, including this case. Now, you can tell the transcription is messing these some of these words up, but you understand what Mr. Odou was saying to Judge Hardy. And Your Honor, you can read through, continue reading through what Mr. Odou was saying. I would highlight on the next page, page 66, line 12. Now, if he would like to use 2023, which is me responding to Mr. Odou, which would be the month before we started the Gallagher trials, that would be inappropriate because then I'd have to reference the Gallagher trial or that date, and we know that's not true in terms of these plaintiffs. The Judge Hardy, just like this court did, overruled Real Water's objection to my use of the date. Your Honor, and then Mr. Odou says, Your Honor, this is line 21. The second to last issue is Real Water has obviously conceded liability. And on the following page, page 67, lines 2 and 3, liability is not an issue in this case. The final page I've added, Your Honor, is page 110. Again, this is during Real Water's opening. Mr. Odou says, as I said, this is line 14 through 23. there shouldn't be one drop of hydrazine. Hydrazine was found by the FDA. Well, actually, the recall was in March of 2021. The FDA tested the water and they found the hydrazine in the concentrate in October of 2021. Okay, it shouldn't have been one drop. It's in the concentrate, so if it's in the concentrate, that means it's in the 5-gallon jugs. Because they use these to make the 5-gallon jugs. They put those big tanks, they mix them around, and those tank, again, this is Mr. Joel Odou, those 5-gallon jugs get filled, and then they go into the retail bottles as well. So if you got a problem with the concentrate, you've got a problem with all real water. That's not disputed. Your Honor, our motion is asking for that exact determination by Your Honor. And I will tell you, Your Honor, and you could surmise this for yourself, the opposition offered by Real Water does not include a single expert retained by Real Water saying that the Real Water products do not contain hydrazine, which is a known liver toxin. Your Honor, I believe you have everything you need in the form of this motion, the admissions or concessions in the opposition, and the lack of expert testimony offered by Real Water. That this product was defective. It included hydrazine, which is a known liver toxin. Every test, and you remember this from the last case, there were 10 tests done of the product. 3 of the concentrate, 7 of the bottled water in the retail bottles, all found hydrazine. There's been not a single test that did not find hydrazine. And finally, Your Honor, I believe that he has resolved or settled with us. And as a result, I don't believe the court should consider their opposition. Does the court have any questions, Your Honor?
I will. I just want to hear what everyone's side is. I have a lot of thoughts.
Sounds good, Your Honor.
Okay, we're here from the opposition.
Good morning, Your Honor.
Good morning.
Plaintiffs try to really generalize and gloss over this to not address certain specific important facts in this thing. They try to claim that, hey, the causes of action are the same. Real Water has admitted in the past that its product was defective. Therefore, issue preclusion applies, and we can just jump straight forward to damages. It's not disputed that hydrazine was in the water, and it shouldn't have been there. That's never been disputed. And what is important regarding this motion for summary judgment
it's not really a motion for summary judgment. I mean, I wrote down summary judgment. We did talk about experts.
That's what they call it.
But I mean, I had a question regarding that. Because at the end of the day, I'd have to look at it. If it was a summary judgment motion, of course, I would look at the moving parties' evidence and then I'd look at the opposition and determine whether there's issues of fact and like, and this isn't that motion. I had thoughts about it. I don't know if it fits under 5-star, right? But go ahead.
Well,
And what do we do? Because I mean, I did read the reply, and starting on page 8 of the reply, there's a transcript regarding, I guess, the opening statement and specific statements that were made. And there was a concession that, Real Water made people sick and so on and so on. So what do I do as far as this case is concerned?
Well, that's where I think 5-star comes in. There's 2 important issues here. Plaintiff has completely ignored the issue of causation. It only talked about Real Water's concession and that they've said it multiple times and that, it's been overruled. Okay, these conversations, all these excerpts that were just brought up today were attorney comments outside of the presence of the jury regarding further discussions of prior motion in limine hearings. And it's not testimony and it's not evidence. Here's the important factors is that causation is an issue and you can't just gloss over that and jump to damages. The other one is the fact that liability.
Wasn't causation an issue in the prior trial?
Yes, it was. This motion was denied in the prior trial.
Well, no, here's my point, and I think this is an important one because there's a distinction between liability and causation. And what I mean by that is liability would be whether or not Real Water was a defective product unreasonably dangerous pursuant to restatement of torts 402A. The next issue comes down to causation, and we had significant discussion regarding causation in the prior trial. And the thrust and focus of that would be based upon the medical evidence, right? And for example, and I see we have different plaintiffs here, but if real water was admitted to be a defective product, that doesn't stand for the proposition that everyone that suffered some alleged harm can automatically say, look, as a matter of law, this liver problem I have was as a result of the ingestion of real water. That's not what would happen. What would happen is, I guess, we look at the medical evidence and the jury has to make a determination on that issue potentially. But my point is this, I have had many cases where, for example, lawyers have, in a simple negligence case, have stipulated the breach, but they said, look, judge, everything else is on the table. And it happens a lot.
Well, that's the problem here. We're
This may shorten your speech. Your Honor, I like where you're going on this, and
But that's what the law
no,
is, right?
no, I know, I agree.
I
The
mean,
reason I put that out there is because of what you said earlier. There's gonna be motions in limine that may deal with some of the causation issues separate and apart from the defect issue. And the reason it just came to mind, Your Honor made a point in the last case that we have according to the court, the causation arguments that were briefed in the motions of limine dealt with kratom. That was for Mr. Belsky, and Haley was turmeric.
right. I
And those
remember.
were fleshed out in the motions of limine. So in terms of the causation component of this motion, Your Honor, I'm fine with deferring that until the motions of limine are heard. So that may make that easier for you, Mr. Freeman.
But yeah, and that was our biggest concern, is that their entire motion just said, hey, they conceded to liability. The product's defective. So let's just jump and have the jury decide how much we're gonna give them. There was just completely glossed over the whole causation issue. And that's where we took exception because
But here's my point.
it's never been decided.
I didn't.
You did, Your Honor.
That's why we opposed the motion and expect you to not again.
Yeah, I know, I didn't gloss over that. Because as far as the product itself, what position is Real Water gonna take?
Yeah, I think at this point at trial 4, we're not gonna come in and say hydrazine wasn't in the water. Or if it was, it should have been, or anything different that's been said in these 4, or I guess 3 prior cases.
Because I kind of looked at it differently. Is there an estoppel issue?
Well, again, going back to
I don't know.
the 5 stars, I think
Well,
it hasn't
remember,
been determined.
5 stars is a different issue, right? That's claims preclusion, issue preclusion. I understand 5 star. But I'm talking about estoppel because in a general sense, you can't take inconsistent positions in different courts, right? You can't, especially under the facts of this case, because these cases are consolidated for the purposes of discovery, right? And here's my point. Because, for example, and I remember this, and I respect Mr. Odou for doing this. I understood his difficult position, but nonetheless, there were specific statements made during opening statement, right? And so we're not going to relitigate that, are we?
No.
Yeah, so we're all on the same page.
But here's the problem, is it kind of all ties back to what they were trying to just leapfrog causation, and collateral estoppel should not be based on stipulated facts.
I agree with all that. We're going down a road that we don't necessarily need to go down, because I understand the distinction between causation. I understand the history of causation in the state of Nevada, going back to Perez versus Las Vegas Medical Center, Prabhu versus Avine, Brown versus Cavanaugh, more staccato. I get it, Hallmark. I understand causation. What was the case? There's another Williams. That was my case. I understand that causation.
Well, and you mentioned earlier today, before we started the hearing, about there's going to be issues of medical causation because there's a whole different group of plaintiffs here.
Well, the only reason I brought that up, I read the points and authorities. It appeared to me that were slightly different issues based upon a pre-existing history of some of the individuals that were plaintiffs in this case versus the prior case.
And I'll tell you, no witness is going to come in and say something different about hydrazine being in the water than is going to be different from what the 3 prior cases or in any of the depositions or anything.
Because I don't mind telling everyone this, because when it comes to like for example, independent alternative causation theory and opinions, as set forth in the Williams case, I'm not going to overlook the assistance requirement as required under Hallmark. I'm not, right? Assuming that's being raised. And that's what I try to do. And so there were issues regarding other supplements that were being taken, and I looked at it through this lens. I didn't meet the assistance requirement under Hallmark, right? And from my perspective, the most difficult thing I have when it comes to these types of cases, in most cases, is making sure I understand what the facts are. Once I understand what the facts are, I can, in a general sense, deal with the legal issues, but I need to know what the facts are, right? Because every case is factually different. For example, in this case, and this is just my impression, I don't know for sure, but you'll flush this out for me. The pre-existing conditions of some of the plaintiffs might be a little different. I get that, and it's my recollection in the prior case that went in the trial in front of me, we didn't have any significant issues regarding pre-existing conditions. This one we might, drinking or whatever. I get it.
All right, well, thank
Am I
you.
missing anything?
Your Honor, Joel Odou for Rural Water, just because there are people that will look at this record after us.
Yes.
I want to make sure the record.
Oh, absolutely. Mr. Odou, you know how I feel about that.
I do, Your Honor. And I just
Make your
wanna-
record, sir.
I just want to add to the record that Brent Jones' deposition was taken in June of 2023. Brent Jones himself conceded there shouldn't be hydrazine in the water.
Right.
That excerpt was played in the Gallagher trial. Anticipate it'll be played in this trial. There is no dispute that Brent Jones, not Joel Odou, but Brent Jones admitted there shouldn't be hydrazine in the water. And so if somebody's looking at the appellate record and thinking, this is a statement of counsel, not the client, this was a statement of the client. We always honored that. He told the truth. And we always honored that in the Gallagher trial and tried to make sure that other people were telling the truth. We had some people that didn't, but they weren't our clients and they weren't plaintiffs. They were others. And we had an interesting trial. Hopefully we won't have that here. In addition, I know this court makes its own rulings. Mr. Parker has represented a bunch of things about the Wren trial. They're neither here nor there. This court will make its own ruling. I think for the record, can just agree to disagree as to those representations. If they come up here, I know this court will take its own look at it and we'll argue with them.
And I try to do that because I don't mind saying this. I read rulings from time to time from other respected judges, even on the federal bench. I don't always agree with, right? I don't. And for many reasons, and sometimes the law doesn't support the ultimate determination, and that's okay. We can disagree as trial judges. And one thing I won't give up is my judicial independence. Won't give it up, right? And I think sometimes how a court exercises its discretion is overlooked, even by the Supreme Court sometimes, because it's not really necessarily what your ultimate decision is. It's, did you go through the process? Did you, for example, good cause? Did you rely upon all the factors? And did you discuss some form of analysis? Just because, and if you go through that, you're exercising your discretion appropriately, right? And they might disagree with the ultimate outcome, but we can quibble on that. But I understand, and that's why I do what I do, Mr. Odou. I don't mind saying it.
Thank you.
Because at the end of the day, if this case goes up on appeal, no other judge's name will be on that appeal but my own, right? And one of the things I've always tried to do, I don't mind saying this, and it's like, for example, in the Williams case, that was a highly contested litigation case. I went the other way from the other trial judge in that case, because I remember I made a determination that the qualification requirement under Hallmark wasn't met as far as a nurse giving an opinion on medical causation. Supreme Court agreed with me. The other trial judge went the other way on that, right? So I'm always going to exercise my independence.
We appreciate that. Thank you. I just wanted to make the record absolutely clear. We all have lived through 3 trials and we'll be living through a 4th, but the record needs to show some of this evidence.
And just to make sure the record's clear, and I think many times, and you have to understand it, I know you know this, Mr. Odou, and what you're saying is, look, that was the status of the evidence at the time. And you can't tell an untruth to the jury, right? You can't. And And if you do, that can be a problem.
Absolutely. That evidence will come in this case.
Yes.
If I don't play Brent Jones's testimony, I'm sure the plaintiff will.
They want to get out in front of it. And here's another, the timing issue, I always tell you why I ruled the way I did, because, I mean, I remember this, I had a young lawyer that came in front of me, and there was a question regarding the timing of the admission of liability. And he said, Judge, you have to understand this, when we filed our answer, we admitted liability, right? And I told him, I said, sir, I wish more people would be that gutsy and do that. And I said, of course you can argue. We've always accepted responsibility from the day that you filed the answer until trial for this event, unfortunate event, but we're going to contest causation, right? And that's kind of how that goes. But I understand that each case is different, but that's why I let the timing come in. Because one thing we don't want to do is we just don't want to mislead the fact line. We don't want to mislead the jury. That's kind of how I look at that. But where do we go from here?
So, Your Honor, I think we have a concession and an understanding and a deferral. So let me give you my impressions of where we are. First, let me address what Mr. Odou said, if I could, Your Honor. I do believe that Mr. Odou gave those representations in his opening. The first one that I pointed out was on page 110 during the Wren trial. But Mr. Odou's opening was based upon the evidence. And I'm not saying that Mr. Odou came in there and admitted liability and causation in those cases because that's how he felt. That was his opinion. His own expert gave those opinions. His own client gave that evidence.
And the reason why, that's why I wanted to clarify that, because typically, not all the time, but most lawyers, when they make statements in front of a jury, it's based upon what the status of the evidence is.
And the other thing that's pointed out that the court made real clear, and I wanted to certainly reinforce this. Blaine Jones, Brett Jones, they gave testimony by deposition, Your Honor, and those depositions have been played in various cases that we've tried. And it's a part of the coordinated discovery efforts in this case. So they've applied in each of the trials. And I don't see how that's going to change because the depositions haven't been retaken. And they've not come to court to change their positions. So again, I believe that supports the fact that this is a defective product, one that does not meet the consumer expectation test. No one would expect to have a liver toxin in a bottle of water. So I think that Mr. Freeman, on behalf of Real Water, has conceded that the product was defective. It was defective when it was made, it was defective when it was distributed, and it was defective when it was sold and consumed. The causation issue is one that we will delve deeper into on the motion of limine practice. I think that's the deferral, Your Honor. And I think you will deal with that causation issue at the time. And to the extent that the Real Water defendants or any other defendant can prove in accordance with Hallmark that these allegations of prior drinking or prior or some prior condition caused or contributed to their acute liver failures or their liver injuries, then we'll see at the time of the hearings on the motions in limine, Your Honor. But I do ask that the court apply issue preclusion as to the defective nature of this product based upon the cases we've cited and the evidence that's been produced now in 3 trials. And I think that's where we are here.
Your Honor, we don't see the issue as a deferral. We would say if Mr. Parker needs an order, it would be granted in part.
Yeah, I mean,
obviously,
but this
the
is,
court always
well,
says-
here's an issue, and I mean, I kind of look at it from this perspective. Is this really and truly a 5-star capital issue, right? As far
I don't think it is. We didn't offer evidence opposite. The evidence is the evidence.
and isn't this more akin to an estoppel issue potentially?
I don't even know if it's a estoppel because we haven't taken an inconsistent position.
Well, yeah, I mean, if you took, I understand what you're saying. Yeah, right. I mean, and here's my point. If hypothetically you took an inconsistent position and stepped back from this and made another argument or something like that, then potentially that might arise to us an estoppel. That seems like the bucket it would come under to me. You
If
know,
we did that, I don't anticipate that happening.
what do we do, Mr. Parker, with that? Because it appears to me Mr. Odou is not gonna do that. And here's my point. I don't mind telling everyone this. I mean, one thing I try not to do, I don't wanna have error.
No, no, I,
Right, I don't want, I mean, I don't wanna have error. I don't. I'll just tell you that, because that's kind of how I look at cases. Because I don't want these cases, I wanna try it one time and let the Supreme Court hopefully affirm me. That's all I want.
so, Your Honor, I call it a granting of the motion as to the effective nature of the real water product. Because
Okay,
this-
but remember this, and I have made a little note here. With a question mark, summary judgment?
So we phrase it as summary judgment because we believe it disposes of that issue for this trial. That there
Okay.
won't be any argument of the defective nature of the product. That's why we phrase it, but we base it on 5-star because it's issue preclusion. That issue will not come before this jury, whether or not it's a defective product. And I believe Mr. Freeman has conceded that that is not they're not going to take the opposite position that the product was not defective. So if that's the case, I believe the court can grant or sign an order indicating that
What
this
bucket
issue.
would that come under as far as procedurally?
We don't see it as issue preclusion.
Yeah, but and also, I don't think it's
I kinda-
quite conceded. I think the testimony and evidence in the past 3 trials and all the discovery is conceded that.
Okay, all right, oh, I
I didn't
understand
come
where
up
you're
today
going.
and make some big proclamation.
Maybe, when is it the responsive motion deadline again?
28th.
It's coming, it was extended too, right, the 20.
It was 26th, I think we moved it to 28.
Yeah,
Because this is what I don't wanna have. I don't wanna have happen where potentially I make a determination, it's not fully vetted. And we have a new trial based upon an erroneous decision I make in order to cut corners. Because I'm wondering if. I mean, Mr. Park, you can file a motion for partial summary judgment on a defective product. And if they don't have any evidence to the contrary.
I think this motion does that in part, Your Honor, because as you can see in the legal analysis in the motion,
Let me see here.
yeah, take a look. We bring this under 56 as well.
Okay,
So I think we're covered there. And this is how we did it in the other cases, Your Honor. We did it both under Rule 56 and under 5-star. We thought we covered both bases. We also, like I said before, in addition to the Rule 56 analysis we provided, we identified the Allison case, the Shoshone case, and the Ford Motor Company case. So we covered that. So under Rule 56, the court can grant the motion for summary judgment as to the defective nature of the product. And given exactly what Mr. Freeman just said, and I'm not attributing this to Mr. Freeman's opinion, this is what the status of the evidence is in this case. They don't have an expert who's going to say to the contrary, and their prior expert, Mr. Goldsmith, admitted that the product had hydrazine in it and was defective. So I don't think there's an issue here, and I think the court can grant the motion under summary judgment. Again, we analyze it under Rule 56. That's what our motion says at page 6, starting at line 20. And again, Your Honor, we indicate on page 5 of the reply a Rule 56 analysis. So you can grant that motion under summary judgment. Again, it's only on the issue as the defective nature of the water product. And if Mr. Joel, if I understood Mr. Joel correctly, Mr. Odou correctly, he would ask that the motion be denied as to the causation element as opposed to a deferral.
well, I think there's two reasons. Number one, of course, I think they push back on causation in general and the opposition. But I think secondly, with Mr. And I listen, Mr. Odou saying, look, we don't think the proper basis would be a claims preclusion issue. It would maybe be something else,
Yeah, I heard that.
right?
that's right, Your Honor.
I heard that part, Your Honor. And like I said, the court can make its own decision, the court will make its own decision in terms of the causation, be it denied or deferred, understood, but we did analyze this under Rule 56, and I think the court certainly can grant this under the Safeway case. There is no competing evidence. We have a concession on behalf of Real Water based on the lack of expert testimony or opinions to the contrary. And we have, in addition to that, Mr. Brent Jones, Mr. Blaine Jones' own testimony, the president and vice president.
Your Honor, for the record, I can add Nevada, there is Nevada Supreme Court precedent. It's LaForge v. State University and Community College System of Nevada, 116 Nevada 415 2000, and it's at page 19, quote, issue preclusion is a proper basis for granting summary judgment. So it is proper if issue preclusion applies to grant summary judgment on that basis. As laid out in the motion, I do think issue preclusion applies, but ultimately the question on summary judgment is there a genuine dispute of fact that Real Water was defective and unreasonably dangerous under restatement section 402? And I think we're all in agreement here that no, there is no genuine issue of material fact. So I think the court can grant summary judgment under Rule 56 on liability for defective product, not causation, based on Rule 56 and based on the doctrine of issue preclusion, together independently.
Here's my question though, are the facts of this case, do they fall squarely under 5-star? And I can understand why potentially, and that's not a surprise, whether I can grant summary judgment based upon issue preclusion. I mean, I get that, but I'm looking at the status of the record. That's what I'm looking at. Where are we at? Because, for example, in this case, we had uncontroverted facts that Mr. Odou pointed out. Is that a better way to say
That's a
it?
better way to say it. Thank you.
Yeah, we had uncontroverted facts that Mr. Odou pointed out, and he couldn't walk back from that because that was the evidence. Okay, we have that. And then we can't overlook, let's go back and do a 5-star analysis, right? And that's kind of my point, because the way I look at this, I don't mind saying it, I think this is an issue that should be resolved before trial. We do have different parties. I understand there was a privity issue raised, but
Yeah, the privity argument, I didn't address, Your Honor, in an oral argument. We addressed it in the reply. I think it's a non-issue. The privity that they're using is misplaced. They're trying to use it as to the plaintiffs, where the case law says you use it as to the defendant, the party it's being pursued against. In this case, Real Water was a party to all of the actions, all the trials. So I didn't waste the court's time with that. I think the court probably saw through that argument. Your Honor, without belaboring this any longer, I still believe, given what Mr. Pepperman just said and how the case law plays out, and the fact that we both mentioned the 5-star analysis and Rule 56, that the court independently could make a decision on Rule 56 basis, given what's the evidence in this case and how it's been described by Real Water's counsel. I think those concessions are determinative under Rule 56, Your Honor.
Well, in Rule 56 aside, on your comments on, is this issue preclusion? That's another big part of our opposition here, is that they don't meet 3 of the 4 required factors for it to be issue.
and I haven't overlooked that. For example, you say on page 17, collateral estoppel should not be based upon stipulated facts, for example.
Exactly. Exactly. I mean, the only factor that meets is that it's Real Water is the same Real Water that was in the other case. There has never been, they've always been stipulated facts. There's never been a determination. You'll recall in Gallagher, the only question on the special verdict form regarding Real Water was the amount of damages. There's never been a determination on the merits actually litigated on not only causation, but also liability. And that was essentially a major part of our opposition.
Mr. Pepperman, you get the last word, sir.
Your Honor, I respectfully disagree with Mr. Freeman. I mean, it was actually litigated. That's why he's referring to all the evidence of their own witnesses admitting that hydrazine was in the water. and it
Okay,
shouldn't have been there.
I get that, but here's my point, and I think this is a valid point. Shouldn't that be in the motion? You see where I'm going on that? I don't mind wasting, I don't want to waste anyone's time, but it appears to me that this is the type of motion that you could have just filed and been straight up. Look, Judge, they don't have any evidence in this case.
We say that, Your Honor. We
But-
say
but
that in
what is-
reply. We say that in the, I'm glad you said that. Your
But I
Honor.
mean-
We said that in the reply, and we indicate in the reply that they don't have any evidence to the contrary, and in fact, attach the expert report saying,
Okay,
agreeing with it. So if we were to take issue preclusion out of the
that's
out of
my
the
point.
discussion, that's right, and that's where you're going. If we were, and I was listening to Mr. Pepperman.
That's my
talk to the
point.
court. If you take issue preclusion out of the equation and you only evaluate this on Rule 56, well, you have enough right now because there are no material issues, genuine materials of fact that preclude the granting of the motion. Because what you have on one side, plaintiff saying it was defective. Well, if I can move over to the defense chair here, defense saying it was defective. That's it. That ends the 56 analysis under Woods versus Safeway, Your Honor. And that's what we're asking. The court can do that separate and apart of the issue preclusion claim. And that's all we're asking for the court to do at this point.
Okay.
But we did say that in the reply.
I kind of know where we're gonna go, but let's go ahead. What's any, Mr. Odou or anyone?
We don't really have any further. It just seems like granted in part on summary judgment makes the most sense. I would disagree with Mr. Parker, the legal mechanism to resolve the causation thing. Honestly, we can deal with that. I don't want to take up the court's time. We can deal with that later.
Oh, yeah, as far as causation is concerned. Here's my next question, and this, I'm doing this from an appellate record perspective. It was raised in the reply. Is there a supplement you want to file in that regard, or?
Your Honor, we also said it in the motion. So it's in the motion and the reply.
Let me, where's it at in the motion? Mr.
No worries,
Parker?
Your Honor.
And what I'm talking about, not the collateral estoppel or,
No, you're talking about just the Rule 56 analysis.
exactly.
No, I'm with you, Your Honor.
That's all I'm.
So
talking-
we start with on page 6, statement of disputed facts. It should be undisputed
Okay.
facts. The fact that the water was defective. We indicate that it was coordinated for discovery purposes from the first line 6 through 9. We indicate the results. And we indicate transcripts where Real Water, of course, said that they weren't going to argue it. But we also talk about, if you go to lines 10 through
And what page are you on, sir?
page 7.
Okay, I'm right there.
No, the reply is on, no, that's different. This is on the original motion.
No, this is in the original motion.
Yeah.
No,
Oh, I'm sorry. I see what you're saying. I'm sorry, Your Honor. I was looking at their opposition. So on page 4 of our motion,
Let's make sure.
we start out by saying this is the cause of plaintiff's injuries is Real Water's hydrazine laced water product, and Real Water's failure to warn the public about its dangerous and defective product. That's the start of it. And it says, Real Water's failure to warn consumers was a substantial factor in causing plaintiff's injuries as a part of the outbreak across several years, 2018, 19, and 20. And then we said, all of these facts have been established through depositions and trial testimony. And that's true. So even if you take away the concessions or admissions by counsel based upon the evidence, that's what we set this motion up to be about, Your Honor. And so when we go to Rule 56 on page 6, we indicate that we ask the court to do an analysis under Rule 56, and then we go into, we prove that the defendant was either a manufacturer, distributor, or seller, which is on page 7, line 2. the product was defective, which is, we've already said is based upon the plaintiff's expert reports and the position of defendants, they agree. The defect existed when the product left the defendant's possession. We all agree with that. And the product was used in a manner that was reasonably foreseeable. We all agree with that as well. And finally, the defect was the legal cause of the damage to the plaintiff. That's the only thing that's being disputed. Everything else has been admitted to. So, Your Honor, we believe that you can find that it was a defective product under the Shoshone case, under the Merck case, and under the Trail case. And the last paragraph of this page, not last paragraph, but
What page you at again?
13 to 18.
I was following you. What page again?
We're still on page 7.
Okay.
That's when we get to 5-star, but you don't have to apply 5-star to rule.
That's what I'm saying.
I agree. And I think Mr. Odou and I agree on the first part of that. It could be granted as to the defective condition of the product. But he and I disagree of whether or not it should be deferred to the motion in limiting practice as to causation or just denied as to the causation. And that's fine. I can live with that. Denied without prejudice as to causation, granted as to defective condition of the water product. I think we agree on that, Sean.
I think we do, and. You know,
And that's what I'll do. I'll make it easy for everyone.
Thanks.
All right, thank you.
Yeah,
Talk
'cause-
about the other issues.
yeah, we can talk about everything else. All right.
Your Honor. Excuse me, Colt Dodrill,
Yes, sir.
counsel for Nevada Beverage. The motion was not filed against my client. I did not file an opposition. I just want to clarify that any orders are not against Nevada Beverage and that no rulings of the court today can be held against Nevada Beverage, and we can address at the limine stage how those apply at trial.
Your Honor, I disagree with Mr. Dodrill legally. I think that as a client, as a part of this chain of distribution, that he's impacted by this decision. He chose not to do an opposition. He, who's also a distributor, opposed it, but then we resolved. So I think if he had this concern, he should have filed an opposition and argued the motion, argued his opposition, but he didn't. Whatever effect it has, it has.
All right, let's hear from you, sir, on that issue.
Thank you, Your Honor. As Mr. Cavanaugh stated at the beginning of the hearing, there were no retailers at trial. I don't believe there's been a verdict yet against the distributors. There is ample evidence through Hallmark and other experts that will address and point the difference between the retail product distributed by Nevada Beverage and the 5-gallon product that's been associated with the outbreak. The courts and the juries have not had an opportunity to make those decisions. And I don't believe that any issue against Real Water, including its admissions of liability, which have not been briefed, can be applied negatively against another defendant, which has a right to defend the case. That is a motion in limine that we filed in the Wren case, but we had gotten out of that case. That's not been decided, and I don't think any of those issues are before the court today regarding how it affects Nevada Beverage. And we'd ask that that be deferred to the motion in limine stage.
Well, I think that's a slightly different issue. Here's my question. Number one, the motion was filed. I think everyone understands specifically the law of products liability as it pertains to a defective product and reasonably dangerous. Clearly, the manufacturer's on the hook for that. From a policy perspective, so are the distributors and retailers. Secondly, has there been any evidence offered by any of the distributors or retailers that hydrazine wasn't in the water and it wasn't a defective product? Because here's my point, unfortunately, and we do understand this under the consumer expectation test. There's a policy reason in place, and our Nevada Supreme Court decided to stick with the consumer expectation test and not follow the restatement third. I mean, I get that, but we're objecting, but based upon what? Because at the end of the day, if I permitted you to file a joinder right now, do you have an expert?
We have numerous experts, Your Honor, and they deposed some yesterday. My concern.
No. Everybody can have an expert, sir. I understand this, but do you have an expert that says that hydrazine is not a dangerous product, that it's appropriate to have hydrazine in water, and that the real water product wasn't a defective product unreasonably dangerous pursuant to restatement of torts 42A.
Yes, Your Honor. Jim Cavanaugh for ETT1 DBA Terrible Herbs. We do in fact have such experts. And I did not view also this motion as against the other defendants. It wasn't styled as such. And I've been here today on other matters as well as sitting in to observe here. But I joined Mr. Dodrill's comments. There was only one distributor in the entire of the case before you, Your Honor, last year, UNFW. There's several other distributors in these lawsuits and a number of retailers, none of which were in the first case. But back to your question, there are experts that will contest that the amount of hydrazine in real water. Well, counsel can laugh.
I'm sorry,
but,
I'm laughing only because
I mean,
you changed your response, and the judge picked up on it, I picked up on it, you said the amount of hydrogen. You didn't say there was no hydrazine, you went to the amount of hydrazine, so I just thought that was comical. I'm sorry, Jim, go right ahead.
Well, aside from the comic relief from my good friend Teddy found in my comments, there are experts that contest that if there had been 10 times the amount of hydrazine found, it still would not have affected the health of these plaintiffs. So, I mean, these are motion and limine issues, shouldn't be in any way applied broadly against parties that, were not part to the prior cases. And again, I had no idea that's where plaintiff now is looking to push the court to make a decision which would apply beyond what the stipulation issues were in the prior case with real water defendant.
Your Honor, this is gonna be quick. EDCR 2.20 tells us, all of us litigants, how motions are supposed to be handled, how opposition is supposed to be handled, replies and joiners. Key, the distributor, recognized that and filed an opposition. They chose not to, both Terribles and Nevada Beverage. The other thing is, because they both, I'm sure, are aware of this, when the same issue came up in front of Judge Kishner, not that the court is relegated to Judge Kishner's decision, she applied this finding of liability against Terribles in that case. So certainly Mr. Cavanaugh is aware of that. So Your Honor, we know what 402A stands for, restatement section 402, section 402 stands for. And certainly they should recognize that. If they chose not to do oppositions, that's on them. But the realities of the court's decision is, it is what it is. And if they want to file some other motion in limine, for whatever reason, they can try, but it doesn't change the law of the state of Nevada. So I don't have anything else to offer Mr. Dodrill or Mr. Cavanaugh, Your Honor, and I think the court's already made a decision.
All right. And this is what we'll do. And I've made the decision based upon Rule 56. As far as the impact, let me think about that for a second. Okay, and I'll issue a minute order.
Thank you, Your Honor.
I might add, Your Honor, I think the situation is very similar in an effective sense to what happened in the Gallagher case when Your Honor found, unfortunately, that one of the distributor defendant in that case, UNFW, had failed to produce data rather than a summary. And Your Honor ultimately heard the issues and made a decision to, I believe, strike a toxicology expert in the underlying Gallagher case for UNFW. And the effects downstream of that to the other, even third-party defendants at that time, Your Honor was holding in abeyance how that alleged bad conduct that your court found might impact the other defendants. And I think this, in principle, is very similar as well. And Your Honor should consider how a stipulation by one defendant who's a party to a case could affect other defendants that were not in the Gallagher case at all. And that's the main point. I had no idea this matter was aimed at my client, who was neither a party to the prior litigation or any of these 5-star factors that that Mr. Freeman ably already argued in his brief to the court.
But what we've done, just to make sure everyone's clear, we've deviated from the 5-star and we've approached it, Rule 56.
That's number one.
So the target's moved again.
No, but when I made the ruling, after we made a ruling on Rule 56 and that, right? Am I correct, Mr. Odou?
That's the way we understood it.
Okay,
And Your Honor, the last comment made by
Okay.
Mr. Cavanaugh is he conflated a discovery issue where NFW had an issue with the actual source documentation versus a summary, with now a 56 decision.
Well, I would say,
Rule 37.
I would say my
that
good
he's
friend
talking
Teddy
about.
Parker's conflating a discovery decision and sanctions that Judge Kishner ruled in Hunwartson with issues here related to a Rule 56 ruling. So I think the conflating has already happened by Mr. Parker.
What do I do in this respect? Because one of the other distributors, right? They filed an opposition and no one, and your clients didn't. What do I do with that?
Your Honor, I think we look at EDCR 2.20, we look at the four corners of the moving papers. Nothing in plaintiff's motion for summary judgment is saying they're seeking a ruling against Nevada Beverage. Nevada Beverage doesn't appear in that motion except in the caption. And nothing puts us on notice that we had an obligation to oppose that and that they would be seeking essentially a slam dunk against us when we weren't in any of the other cases. So I would take a look at that first to see that we were not simply put on notice that motion was directed at the distributors.
Here's my question in that regard, because when it comes to the restatement of towards 402A, for example, if I granted summary judgment that a product was defective, and that's as to the manufacturers, how does that operate as a matter of law downstream when it comes to the distributors and also retailers? That's really the issue.
And Your Honor, I agree, and that's why Key objected to it. Terrible suffered a fate based upon the restatement section 402A. And now to say that they were not aware of it, that is troubling to me for counsel to say they were not aware of the implications or the consequences of this motion. And still believe that they're very knowledgeable attorneys. Mr. Cavanaugh is a very good attorney. I've known him for a long time. Mr. Dodrill I've not known for long, but he's shown himself to be a good attorney. And for them to suggest to this court they weren't aware of the downstream effects of this decision goes against knowing products defect liability cases and strict product liability. That doesn't make any sense. They're inconsistent positions for them to take. So Your Honor, I think he did what it believed was necessary as a distributor. And unfortunately, Terribles as a retailer did not, and Nevada Beverage chose not to as well. And I think the court is correct. You can look at the motion and the reply, and they both analyzed Rule 56. And so even if they didn't believe it met the 5-star requirements, they should have opposed it based on Rule 56 and chose not to.
Your Honor, Colt Dodrill, Bar 9000, counsel for Nevada Beverage. In plaintiff's reply, he states that Cahey was not proper to oppose that motion. So I find counsel's argument here a little off, and I would direct the court to that language and take that under advisement. And I think this whole issue should be kicked to the motion at limine stage. We filed in the Cave case, which was not briefed because we got out, some issues under Fro and Lomasto and some constitutional issues, how an admission and stipulation by one party cannot be used to adversely affect the other party. We plan on filing something similar in this case. And I think those issues here should be deferred to the motion at limine so the court can be fully informed.
I understand.
Thank you, Your Honor.
Your Honor, just for the record.
Mr. Odou, go ahead.
Because I'm a little bit lost. I understood the court's preparing an order. Is Mr. Parker preparing the order, running it past me and then we?
Yeah, well, he's going to prepare an order. I think the issue I'm taking under submission would be the extent of the ruling as it relates to the distributors.
Thank you, Your Honor. Just want to make sure we're
And retail.
clear on our.
Retailers.
assignments.
All right.
Thank you.
Okay,
Have a good morning. Thanks again.
Thank
I'm
you.
sorry we stayed so long.
that's okay.
Much
Thank you, Your Honor.